Earlier session has already been well received. Those who have not watched that, they can always watch along with the other webinars. Today is evidentiary value of confession by a co-accused and statement of accomplice as witness. Earlier also we did interplay. So the interplay with the sessions has always been a fascinating part for all to understand. And we all understand since the situations have lived back to normalcy, and we hope and pray that it continues to remain such and we move for the betterment. Without taking much time, I will request CHANJANA ELSA Phillips to take the things forward. Over to you.
Thank you, sir.
Yeah.
Once again, wonderful evening to each and every one of you here who are here. Now, I think we have just 1 hour to do this session and quite a bit to be included in it. So I'll move on with the topic. I think the last session, what we had done was regarding confession. We had to find a difference between admission and confession. Now, one step ahead is what we are going through. That's about confession. When we are listening to this session under the presumption, knowing that or understand under the presumption that we know what a confession is, know what an admission is, let's move on to something called confession of a co-accused. Now, who is a co-accused? A co-accused is a person who is accused with you in the crime. Now, you have section 30 of the Evidence Act, which tells you when there are, so this section 30 comes into picture only when there are co-accused. So, or when there are more than one. So that's what the section tells you or starts by telling you when more persons than one are being tried jointly. So it is only under such a so that itself is a limitation for the application of section 30 telling you when more persons should be tried jointly for the same offense. So it's not that you being an offender, but then you being an offender for the same offense. And a confession is made by one such persons. So when you make that confession, the law itself is qualifying and telling it that how should that confession be? If you make any kind of a confession is not enough, that confession that you make should be affecting himself. Himself is a person who is making the confession. So it should be affecting himself and some other person. So that is when, so that it is under such a situation that you call it to be a confession of a co-accused. And that's the reason why I told you for that particular purpose, we should at least know what a confession is. And like how we had done in the previous class, a confession will always give an inference as to the guilt of the person. So that such kind of a statement, a statement which tells, which shows that I am not part of a crime can never be a confession. I would have spoken about the crime, but if I don't speak about my inclusion in it, then it can't be called a confession. So that's why I said we should be clear in what is a confession and what's an admission. So section 30 comes into picture only if you have made a statement which affects yourself. That's when you call it to be a complete confession and some other person. Who is that some other person? The section has already told us who has been jointly tried with you for the same offense. Then, under such a circumstance, the court will, so this, the phrase that says is, may take into consideration. Because, now why is that term, may take into consideration? Because if it is an relevant fact, falling from sections 5 to 55, generally they are evidence that you will rely upon for the purpose of the case. Under section 30, the statement that you make will not fall within the definition of evidence because it is not taken on oath. It is not being cross-examined. It is just a mere confession which he has made. So that's where they're saying, now, so the court may take into consideration such confession. So when you are taking, so what we will have to analyze as law students, or when we are analyzing it, what we will have to look to is, now what are those, when you say that the court may take into consideration, obviously we understand that it is not a mandatory rule that the court takes it into consideration, but there are circumstances which the court will want to comply with if you want the court to rely on such a confession. That's why it uses the word called, the court may take into consideration such confession as against such other person, as well as against the person who makes such confession. So this is confession of a co-accused. All right. So now when we are doing it, so I hope you understand, this is what we are looking at today. So what could be the evidentiary value? Now, when we speak about section 30, if you have checked, the title also speaks about something called an accomplice. An accomplice is also included under the Evidence Act, or the statement that an accomplice gives is also included under the Evidence Act. But then it's under section 133. Now, why I spoke about accomplice here? Because an accomplice is a person who's participated in the crime. So he can also be jointly tried. He can also be a co-accused. So that is a reason why I have clubbed confession of co-accused along with statements or the evidentiary value of the statement made by an accomplice. All right. So let's see how it is. So when you look at the confession of a co-accused, in the beginning or at least before 1872, this concept was not there. This concept of a confession of a co-accused was not there. And generally English law also was not in favor of going in with the confession of a co-accused. The reason being that, they believe that a prisoner is not liable to be affected by the confession of his accomplice. So because of that, or the other person, the accused, is not to be, liable to be affected because the accomplice has come up with a statement. So because on those grounds, generally English law has not accepted it, but then it is only after the 1872 Indian Evidence Act that this section 30 was being put forward. Now, what are those ingredients? So when you're looking at 30, what is it that the courts will look at? So that is what first I will concentrate on. Now, first, that the court is going to look upon is, it has to be a proved confession. So that's something, because that's why, how do you understand that this is what we are looking at? Because the section tells you affecting the statement that you make should be affecting yourself. You should be accepting the pain of the law. You should be accepting the grievances, or you should be addressing the effect of the law upon you. So that is why they say it should be a proved confession. So when you're looking at section 30 as a court, because last time when I took up the case, quite a few had a problem with noting down the cases. So what I thought is, the case laws we will do in the last, around 5 to 6 case laws, landmark decisions, which I'll just give you based on, how this has, with regard to the law that is dealt with in here. All right. So first we go with the ingredients of what section 30 could be. One, it has to be a proved confession, meaning to say that if it falls short of a confession, that is, the confession made by this person under section 30 should affect himself and also some other such person. One. And second, it has to be sufficiently proved. Under these two circumstances is when you say that the confession is proved. First of all, it has to fall within the definition of confession. And is that alone enough? No. When I make that confession, I should be keeping me as part of it. It should be affecting me and whoever it is. And along with it, it should be sufficiently proved. Second, we will not take any, because when you have made statements, there can be statements which have admissions in them as well. So statements with admissions and confessions are not being encouraged. Under section 30, we look at only confession. And for that, you might have to distinguish between admission and confession, which we have already done in our previous session. Now, the third is, what will be, now when you're making the statement, what should be the contents of the statement that you are making? What is it that you will include? Okay, there you should have an offense. You should have incriminating factors which are relevant to the offense. You should be able to say that this the statement that you make should be able to reflect the motive or preparation, conduct, the intention, knowledge of the offense. That's when you say that it is a confession. So contents of a confessional statement. Then comes Apart from all this, the most important test, the courts have called it to be the factor of lending assurance. What is that? Lending assurance. Don't forget, it is a confession. Now, who is the person who is confessing? The confession is by a co-accused. When the confession is by a co-accused, and when the court wants to rely on such a confession, the court, what is it that the court is looking upon, or what is it that the court is looking at? The court is looking at something called a lending assurance. That is, this is, something which is authorizing the court to apply Section 30 only in appropriate cases. Now, this Section 30 is not a supplementary evidence. Let's say, for example, in the sense, when you come up to the prosecution case, let's say it's a circumstantial evidence. And when it is a circumstantial evidence, those of you who have gone through the law of evidence will understand the circumstances should be complete. The chain of circumstances should be complete for you to rely upon such an evidence, circumstantial evidence. You should not bring a doubt, an improbability in the mind of the judge. But then, that's the same rule that is applied here. When the prosecution is dealing with the case, in case there is any kind of a gap in the evidence, the law says the confession of the co-accused is not to be used to fill in that gap. Okay, there is a gap. We are not able to get any evidence. So we'll ask the co-accused to do a confession. We'll fill it up. No. The very simple reason being, the statement under 30 is not evidence. You cannot find a conviction of a case only based on Section 30. Because the very fact that it is not taken to be evidence. But when there are other evidences, then these statements can act as a lending assurance. I hope now you understand what the concept of lending assurance is. The very simple fact that the statement recorded under Section 30 doesn't fall within the definition of evidence. And moreover, and hence for the same reason, it cannot be used to fill any gap, any lacuna the prosecution has in its case. All that this will be used for is when all evidences are there, when there are other evidences, these statements will act as lending assurance. So that's the factor of lending assurance. So that's one of the tests, or that's one of the rules that the courts keep in mind when they rely on the confession of a co-accused. That's a reason why Section 30 tells you the court may take into consideration. When is it that the court is going to take into consideration? You may take into consideration when you feel that this Section 30 statement will lend you an assurance. Assurance with regard to the guilt of the person. Assurance with regard to going forward for the conviction. So that's where you use this statement. Okay. So, and moreover, because you say that it can be used, obviously it is not something which is conclusive. It is only a corroborative. It's not a substantial piece of evidence. It's always a corroborative piece of evidence. That's why they say you may take into consideration if everything goes well. And all the other evidences are pointing to you, then there is nothing which stops you. Obviously, it can be taken taken into consideration as a corroborative evidence. So that's something which we will look at. Okay. So then comes. So we have said for the conditions for Section 30, that is confession of a co-accused is 1, it has to be a proved confession. Second, it has to be a confession at the outset, because we have to be clear on what admissions and confessions are, and remove admissions and we are taking only confessions. Then what will be the contents of the confessional statement? Obviously, the content of the confessional statement should point out to your guilt, the guilt of the maker, and not the first thing that should happen. Then even when you are accepting this is just an assurance that yes, this has happened. His statement can be taken along with other evidences, but it's not a substantial piece of evidence wherein when there is a gap for the prosecution case to fill it up. Next, when you look at how do you understand that it is of corroborative evidence? Because it says, the section itself says that the court may take it into consideration. So when you say that the court may take it into consideration, it's not a conclusive proof and it's not substantial. Depending upon the circumstances, the court gets to rely upon it. And then you have the test of acceptability. Okay, now, so there you're looking at, so after all this, so you want to see whether the statement can be taken. Okay, probably the statement might be a confession. I would be making a confession. So when you're making a confession, just because it is a confession, no rule says that you have to accept it. There is nothing which says that the court, I made a confession under section 30. I am a co-accused. I made a confession. So please take it. No. The court should understand that, it is something which the court can accept. So the test of assurance and acceptability goes together. One, assurance is, I'm strengthening it. The statement strengthens other evidences and it doesn't stand alone to convict you. And then beyond that, if the statement has to strengthen, then it should be something which the courts are able to accept. That's when the court will be able to tell you, yeah, it is something which is giving you a strength to the case. It is something which is added to an assurance. So that's why I said, when you look at, so there the court is trying to look at acceptability. Okay, so is it acceptable or not? Now there, the court generally looks, so what is the test that has been laid down? So when the court takes up that particular statement, the court will first look at whether the statement is sufficient when it stands by itself. That means if I have made a confessional statement, you are taking my statement alone. Now you are looking at whether that particular statement is sufficient by itself, if it stands on its own. Whether it is sufficient by itself to justify what? The conviction of the person making it. So when I make it, so that statement, would it be good enough to say that, yes, this statement alone is good enough to show her guilt? Such should be. So such kind of a statement is what I should make. And even when you say that that is a confession statement that has to be made, obviously, as we have all known and we have gone in the previous sessions, this statement that I make has to be voluntary, and second, it has to be trustworthy. So that's a double test that the court looks in for any kind of confession. So whether it be a confession of a co-accused or any kind of a confession, that is what they look at. Okay, so first, what is it? That it has to be voluntary and trustworthy. So based on that, so first I will understand that you're making it voluntary. I will try to understand that the statement that you're making is trustworthy, and then I will look at. Then the test is it sufficient? Even when you made that, is it sufficient to justify your conviction? Because you are the co-accused. When you make it, you should not make a statement which helps you to wash your hands off. So that's what the law is looking at. So thereby, the principle and scope of this particular section is the statement that the person has made of his own guilt. That statement which is made of his own guilt affords him some sort of sanction. If I have made this statement, this will bring me some sort of a sanction. Okay, so only under such circumstance. So, and not only against me and the person whom I have spoken about. So under such a circumstance, this statement is taken. But then the weak side of this particular statement is, or this particular evidence is, it is not evidence. Don't forget, it is not evidence under section 3. It is not given on oath. Sometimes the presence of the accused, because you are a co-accused, the presence of the accused might not be there, or you might not be tested on cross-examination. So because of these reasons, you call them to be a weak tie. So the attitude of the courts are generally that it can be used only in support of evidence. Don't forget about the test that we spoke about, 2 tests. One was assurance. It complies with assurance. That is, everything else is fine. This particular thing is giving an assurance. Okay, so that is what you look at, assurance. And then you also the factors of blending assurance and the test of acceptability. Okay, so the acceptability that you speak about is for the courts to decide. whether it can be accepted or not. That again depends upon the confession, like, as I told you, trustworthy, voluntary, and then if it is showing your guilt, then nothing stops. But never will this be a substantial piece of evidence. It is always a corroborative piece of evidence which has been accepted, and it is never used to fill the gap when there is a lacuna in the prosecution evidence, however, corroborative manner. Okay, so that is confession of a co-accused. Now, because we did with the confession of a co-accused, I would like to bring in one of those concepts which the Evidence Act tells you, which is about an accomplice. Now, that is under section 133. Now, it says an accomplice. Now, there's a slight difference. Okay, that's why I wanted to bring out this. Now, there is a slight difference. Now, 30 told us that it is not evidence as such. You are only a co-accused. You are making a statement, which is bringing you also part of it. And if everything else is fine, I will take your statement also, which is, approving the fact. Now, when you come to an accomplice, section 133 tells you, an accomplice shall be a competent witness. Now let's keep the difference. Now, when we spoke about section 30, it only said when more persons than one are being jointly tried, and if you are one of the such person is making a statement against himself, and if it is proved, then the court will take into consideration, may take into consideration that statement. But then 133 is making a blatant statement saying an accomplice shall be a competent witness. Now, who is a competent witness? We know under 180. Who is a competent witness? A person who is able to understand the question that is posed to you, to be able to give you an answer. So that's all. We don't say that because you are of this age, you can't make a witness. Because you are in this situation, you can't make a statement. No, nothing does the Evidence Act say. All that the Evidence Act says, you should be able to give a rational answer. You should be able to understand the question. So even if you are a child, that's the evidentiary value of Child Witness and Evidence Act. So even if you are a child, if you are able to understand the question posed to you, you are able to give a good answer to it. And, if the court is felt that the child is not being tutored, nothing stops the court. Because the law doesn't say that he's not competent. The law doesn't say that he's incompetent. That's why everyone generally are competent if you have complied with the test under section 180. So don't forget, that means if you are a witness, you are making oral statements which you are being taken on oath. So your statement under 133 is evidence for the purpose of section 3. Whereas I told you that the statement that you make under section 30 is not evidence or doesn't fall within the definition of evidence. So let's say this 133. Okay, so an accomplice shall be a competent witness against an accused person. So who is an accomplice? A participus criminis, a person who's participated in the crime. So he's an accomplice. That's why I connected it with confession of the co-accused. Who is a co-accused? Who has been jointly tried for the same offense. So as far as that part is concerned, there is a common factor between both the sections. Okay, so an accomplice shall be a competent witness against an accused person, and this confession is this conviction that the court is doing is not illegal. Why is it not illegal? Just because it comes from the uncorroborated testimony of an accomplice. Just because it is from the uncorroborated testimony of an accomplice. Uncorroborated testimony of the accomplice means you don't need any other corroboration. The statement made by an accomplice alone is enough. I'll just tell you the section once more. So let's be very careful. So what did we say? Under section 30, when we said you are a person who's been jointly tried and the statement that you make may be taken into consideration. The court may take it into consideration. But when you come to 133, it is telling you, and a conviction is not illegal merely because that statement is not uncorroborated. But, okay, so that means technically, if you look at it, under 133, if you look at it, if I'm an accomplice, okay, and if I make a statement against an accused person, that conviction cannot be called to be illegal. Now, this section has to be read along with section 114 clause B. Now what it says is, okay, 114 clause B, which speaks about court may presume existence of certain facts. So certain facts, the court is given the right or given the freedom to presume certain things. So there you have 114 clause B, which tells you the court may presume. So what is it that the court will presume? That an accomplice is unworthy of credit. Unworthy of credit unless he's corroborated in material particulars. Okay, so there we will feel that there is a slight contradiction between 133 and 114. But let me tell you, when this is a fact which is given to the court, telling the court, you keep these things in mind. Now, why is it? Now, these are rules of prudence. This is a rule of prudence which is telling the court, when the court tomorrow says, based on what you said, I have convicted a person, and if somebody asks the court, how can you convict? The court will have to rely on section 114B to take up that, to tell that I have done it, so I can presume it. So I have presumed him to be unworthy of credit, and he has been corroborated with material particulars. So as a court, so this is like a safety measure. This is to be on a safer side. This rule or this principle is applied for the courts when the court goes for conviction. 133 is, 133 is telling you about the status of a statement made by an accomplice. Telling you that he is a, competent witness. He is a competent witness. Now, when you go with that along with, so when the court is going, well, the court has to accept, because the law itself says that he's a competent witness. So when the law says that he's a competent witness, the court doesn't get a chance to say that, no, he's not a competent witness. He is a competent witness, and just because it is not corroborated, don't think it is illegal or unworthy. It is good law. It is a good statement. So when you make that, we are okay with it, but then don't forget, courts, when you rely on that, you are always given the freedom to may presume. What is it that you would may presume? That he is unworthy, that you decide, that you are unworthy of credit unless he is corroborated in material particulars. So that material particulars has to be there. So you should come up with those material particulars, which in the course of the case will be proved. Okay. So here, I hope you're getting it. So when you club 133 and 114, now just to give you a connectivity to it, I would also just like to bring for your reference a 306 of the CRPC. Okay. Because we are doing with Accomplice and to understand how they work in, I just would like to bring to you 306 of the CRPC, which speaks about a pardoning power given to an accomplice. So there also, so that is a reason why, what I believe could be there is one of those reasons why he's been treated as a competent witness, because this 306 comes into picture sometimes when the court feels that, he has to be pardoned, and if he confesses, his statements can be taken, which will help us move forward with further material particulars. So that is one of the reasons. To me, I felt that, you have made an accomplice a competent witness, whereas the statements made under section 30 are not given evidence unless and until they are further corroborated. Here again, if you apply it in the strictest form, it doesn't say that you have to treat him to be unworthy, but it says the court may presume the existence of any fact which they feel is likely to have happened. So that may presume, which makes it not very mandatory for the court to presume it, but however, court, if you want, it's left to you for you to presume. What do you presume? That he is unworthy of credit. Not because of anything else, but because of the simple fact that he was also part of this particular crime. And being a part of the crime and being a part of being an accomplice to this, you have today turned back. Okay, on the ground, let's say if you're applying 306, on the ground that you would be pardoned, you have just spoken against me. So those are the reasons. So he is treated, because an accomplice generally in the eye of law is treated to be a bad friend. So, he is an unworthy friend. So that's how the court looks at it. So that is a reason when the court is relying on him, because the court looks at him as an unworthy friend, when the court relies on his statement, the court feels that it has to be corroborated. And today, though it has not been said so, that particular rule of prudence that has today become law, that has hardened into a law, is that for a conviction, there should be corroboration of evidence. Not that corroboration is essential. Don't forget, it is not that because 133 told me that, it is not that unworthy of credit. They are not unworthy of credits. Yes, I know that. Not that corroboration is essential for the conviction, but it has become a hardened law that you will go in for a corroboration. The necessity of corroboration has now been taken to be more of rule of prudence, which a judge has to keep in mind. Okay, because as an approver, you will have to prove your worthiness. You will have to prove your worthiness for the credibility in the court. You will have to tell the court, yes, court, I'm doing this, I'm taking this, I'm making these statements because of this. So the test of credibility, that's the difference there. The test of credibility has to be, whereas the confession of a co-accused, one of the differences, one, we said it is not evidence as far as 133 is evidence. Second, what we said is, based on the statement of a co-accused, there is no conviction. The law says, when everything else is there, you take this for a support. But that's not what the law says here under 133. He is competent. Just because it is not corroborated doesn't make it illegal. That's an important difference. Doesn't make it illegal. Then why 140? It is just a rule of prudence. Isn't it contradictory? No, it's not contradictory. It's just for a judge. That's why they say they've included it in the section where it speaks about the courts may presume. They're not telling us. They're not telling the law. They're just telling the court. Court, when you are applying and relying on it, he being an unworthy friend, just see to it that, it will be corroborated with material particulars. However, if you read it with 133, corroboration is not a must, but it's a rule of prudence. So thereby, the test of credibility has to be fulfilled. And how do you go with the test of credibility? You go with the test. So how does the court understand, okay, you can rely on him? There is some kind of a credibility. That's when the court will be able to. Otherwise, the court might presume that, oh, I will have to reject it completely because, there are no material particulars. So that freedom is given to the court. Okay, so thereby, so what you will have to do is the test of credibility is fulfilled when the story that you say, because you are making a statement, the story that you say relates or involves him in the crime. Like how we spoke about the confession of the co-accused itself. When the statement that you make will have to make you a part of the crime. Okay, so if you saw it, or if you are a normal person who saw it, you cannot be. You should actually be part of the crime, and that should. That statement that you make should give all natural and all kinds of probability for you to get convicted. So that is something which section 133 looks at, or at least when the courts try to apply, and when the courts try to punish persons, this is what, or when the court goes for a conviction, this is one of those things that the court will look at, the test of credibility. Whether the test of credibility is fulfilled. Why? Because the court presumes that he is unworthy of credit. So thereby it becomes necessary that the court has to comply with the test of credibility. And once that test has been crossed, then it should be beyond reasonable doubt. That first test has been proved. What is it? That yes, it is credible. His statement has got some kind of a credibility. There is nothing wrong in me relying on his statement. That's credibility. Okay. So once that credibility, I can rely on him, is the credibility. And once that test is being crossed, then the statement must implicate him. How? In such a manner as to give rise to a conclusion of guilt beyond reasonable doubt. That means the court is what you call convinced. The court is convinced that yes, beyond reasonable doubt, he is a person, in case these statements are taken up, he is a person who, can be convicted. All right. So this is why, in fact, I wanted to tell, because most of the time, we get confused with regard to what is the difference. Don't you think that there is a contradiction between both the statements? Is what we would generally look at, what we would generally understand. But then, no. But then it is not any kind of a contradiction. Section 30 is only the court may take into consideration if the court wants, and it doesn't even stand at the level of an evidence. But when it comes to 133, the statement that you're making itself, the law treats you as a competent witness. Only thing for the courts to presume, as a rule of prudence, we might treat you to be, generally the presumption is that you're treated to be unworthy of credit, and hence we would want the credibility to be proved first. And once the credibility is proved, then we go with the second test of seeing that a conviction, there is no reason why I would have a doubt. It's beyond reasonable doubt. It is being proved. So this is what section 133 and 30 is about. And 133, why I took up 133 is also because of this fact that there is this concept of section 306 under the CRPC, which gives him a pardoning power. But then again, 30, when you analyze the sections, you understand that, even though that particular section is there where you are being pardoned, if at any point of time the court feels that you're trying to make statements to protect yourself and you're not helping us in proving the case, you can be taken back for giving false evidence, as well as for that particular offense which you have been brought in, because you have made the statement. So there the difference is the statement will be used against you. So this statement, the very statement that we spoke and saying that you are a competent witness, because tomorrow under 306, if I am giving you a pardon, you become a witness, because 133 permits me, allows me to make you a witness, a competent witness. So when I make you a competent witness, and if you, after getting the pardon, or for you to get the pardon, if you are trying to wash your hands off, the problem is this statement that you made will be used against you. Because your statement, you being a witness there, you would have, the statement that you made would have been recorded under section 164 CRPC to make it a valid confession, and probably you would have been cross-examined. Under such a circumstance, this statement will be used against you, because that's one of the conditions for 164. You are warned that this statement tomorrow can be used against you. On that condition, so we are recording it. So when that recording comes, and if you don't stand with it, or if you don't do your fullest, helping the law to take things forward, what happens is the statement that you make will be taken against you. Okay, so that's the evidentiary value of these statements. So we should understand. So when we read it, we should understand the scope and the evidentiary value of these statements that we are making. So what is the evidentiary value of the statement made by an approver? Generally, in any case, the evidence of an approver will not differ from the evidence of any other witness. Okay, so that is one of those statements that you need to keep in mind without forgetting it. The evidence of an approver will not differ from the evidence of any other witness, except that they will look upon the statement with suspicion. How do you change the suspicion? The suspicion may be removed, and if you feel that the person is trustworthy, that's what I spoke about, credibility, the test of credibility. And then see that, it is a case, the statements that you made is good enough to secure a conviction, then they go with it. So that is the conclusiveness. So under such a circumstance, even if you go for a conviction based on the statement of 133, there is nothing wrong, is what the law tells you. So that's the conclusiveness of the statements made under section, or statements made by an approver, or the confessional statements made by the approver under 133. And then, and as I told you, the test is, it is not that it is outrightly rejected, but because we know 133 what it says, but however, as a rule of prudence, don't forget that. That's a rule of prudence. And as of now, today, depending upon the case laws or looking at the case laws, what we understand is every time the court has accepted, or this is formulated to become a hardened law, that without being sufficiently corroborated, the court doesn't rely. Because why again? That is because 133 always tells you, or is already telling you, that there is nothing wrong in convicting a person based on the statement of an accomplice. So when you're going for conviction, that's something which is serious. Don't unnecessarily jump into it unless and until it is being corroborated. And that again comes under may presume. But however, that is, though it is a may, that's why they say it is hardened into a law. Why? Because there it is a may presume. So tomorrow if a judge says, no, it's okay, it's a may presume, I accept it. So nothing can be done. So that's the reason why they said today the courts, or through case laws, it is being laid down. It is hardened into a law. What? The fact that there should be credibility. Second, it should be proved about your guilt and that you can be punished. That's when it is. So I told you, this is the concept, okay, underlying section 30 and section 133, which a simple outright reading, which will help us to understand it is one and the same. Second, when you read 133 with 114, you might get a picture that both are contradictory. But this analysis of these sections will help you to understand that all of them are different. Obviously, confession of a co-accused, because if you are an accomplice or you are a co-accused, so no doubt in that. So beyond that, but then you should be a co-accused. But that's why they're going on to tell you, if you are, I only saw it, I only knew it. No, you should be a participus criminis. That's why they say the statement that you make should finally put you into trouble, should show your guilt, should be such a statement which you can get convicted of. So that's the reason the statement should come from such a person. It can't be anybody. So all this are for the courts to look at. So one reading of the sections probably might not help us to understand it. But if you analyze it in this way, and if you give a clubbed reading of all these provisions put together, obviously, it will capsulate into the law that is laid down within this. Okay, now, and I told you a couple of cases which, if you want, can make note of are, the landmark decisions, the two landmark decisions which is dealt with confession of a co-accused as well as accomplices. One, as we all know, is Kashmira Singh. Okay, Kashmira. I think last time there was a confusion with the case laws that were discussed. So just to give you those case laws, Kashmira Singh versus State of MP. And then one is Bhubodi, quite an old 1947 case that was wherein, for the first time the court gets the opportunity to deal with and lay down principles. So it is Bhuboni versus Emperor, Bhuboni. Okay, Bhuboni versus Emperor. So these were like a little old. Bhuboni's case was one of the initial cases, and Kashmira Singh's case comes later after that. But so these are the cases which generally we would call, like how you say, Pakkala Narayana Swami's case for confession and inculpate, exculpate, the definition of confession, the Dang declaration. So like how you say Pakkala Narayana Swami, these two are like landmark cases for confession of a co-accused and an accomplice. But then apart from that, for your reference, you can make a note of a couple more of cases, cases being MRINAL, Mrinal Das versus State of Tripura. Okay, so that's like a 2011 case. So there also, the court is again, so it is only the principle that has been laid down in Buboni's case has been reiterated many a times through all these case laws. And, this case is also telling about laying down a couple of laws, which tells you there is nothing illegal. So that's what they're going on telling. Okay, a court every time says there is nothing illegal. We understand there is nothing illegal to proceed with the uncorroborated testimony of an approver, but the universal practice. That's why I say it is now hardened into a law, and it has become the rule of prudence rather. Okay, so but the universal practice is not to convict upon the testimony of an accomplice unless and until is corroborated in material particulars. So there the court, to be on the safer side, the court reads 133 along with 114 clause B. Okay, now, and then the other rule that has been put forward is like how we have said, the evidence is regarded ad initio as open to grave suspicion. The moment you've done it itself, we look upon it as grave suspicion because you are not treated to be, what do you call, a good friend. You're not a worthy friend. So that's the reason why that doubt comes. Okay. Now, if the answer to all these questions is okay to the court, whether he's reliable witness or not, and if the answer is positive, the court can go ahead with it. And if it is negative, then there itself, the matter ends. Okay. So Mrinal Das case also gives you this particular principle. You have another case, which is Somasundaram, SOMA, it is Somasundaram versus State. Okay, so that's again another 2016 case wherein, the High Court had justified, in upholding the conviction done by the trial court, and that was based only on a approver statement. So how do you go with it? So is that fine? So that was being challenged. So there again, the court is trying to bring out the same principles. But again, what the court looks at is when you are going through CRPC provision, wherein you are getting pardoned, there, that is the whole reason. So that's why I told you about the competent witness. So I presume that could be one of those reasons. Section 306 could be one of the reasons why under 133, you are a competent witness, because it says that the procedure under the CRPC for an accomplice, if it is not complied, then it becomes difficult. Okay, so they should be treated as witnesses. They should be examined. They should be cross-examined, and only like a normal witness, if they undergo the whole test of reliability, then they get to, and they have to be reliable. What they're saying should be true under such a circumstance. And if it is corroborated in material particulars, you can go ahead with this. But otherwise, generally, the court avoids it. Okay, so the court doesn't accept. None of the courts accept it. So I just gave you these cases because these are all cases which, have laid down the principles. One very old case which I can discuss is Ismail versus Emperor. Okay, I think it is given as Ismail, son of Hassan Ali. That's how it is given, or Ismail versus Emperor. That's also like a 1947 case. All these cases have also defined accomplice, because accomplice is not defined anyway, anywhere in the Evidence Act. So thereby, who is an accomplice is also being defined. So that has to be understood. So that after that is when you go on with his statements and stuff. So thereby, these cases are important when you look at those, when you're looking at those kind of, when you're looking at law in that particular manner, with regard to, where I need to know who an accomplice is first. Then these case laws will help us to understand who an accomplice is and what statements made by him can be accepted. And at the same time, one of the 2021 case was like Hasina versus State of Tamil Nadu, wherein the state, they're speaking about what kind of an evidence will the accomplice give. So there, they're trying to tell you that when I tell a story, we already spoke about the confession. So when I tell about a story, that story need not correctly point out and give any direct evidence. That might not be always possible. Need not be a direct evidence that the accused has committed the crime. But you can give circumstantial evidences. You can bring in circumstantial evidences. That's why the section also tells you about material particulars. Okay, see for material particulars. If it's something which is a direct evidence, then matter closes there. So that's not the case. So there, you can give in the statements that you make might bring in circumstantial evidences also. That's fine with the court. The court is ready to accept it, and the court accepts it. Okay, so I think with this, we have come to the end of this particular discussion. Section 30, which resembles with section 133 read with 114, but they are two different kinds of evidence which the law looks at. Thank you.
Tarun says, what is the evidentiary value of complainant and witness in a complaint case under section 200 and 202 of CRPC? Can this statement be used as a contradict prosecution version in other cases?
See, if at any point of time, when you look at a complainant, the section 200, when you speak about, is a private complaint, right? It's a private complaint. I was just trying to find out the question once again. Can we get the question once again? It's a private complaint. So there, when you are a complainant, you are not an accused. You are not standing in the position of an accused. You have come up with a case, and you will be first examined, because the court, let me just tell you that in a normal case which comes under from 154 onwards, and when the case is presented, when the investigation report is submitted under 173 and under 190, when the magistrate takes cognizance, based on this, there is a prima facie case which is proved. But at the same time, when it is a complaint, only one the witness. Are you understanding? So you, the complainant, becomes the witness. So there you are totally, you cannot compare the complainant as a witness from accused being. That is only a what do you call, a complaint which has been filed altogether in the absence. Remember, under 200 there is no 173 report. Magistrate takes cognizance based on the statement that you make and after you have been examined.
This is by Tariseti.
So I think you have to be a little more audible, a little more louder. Yeah.
The next is, ma'am, any exception to section 30? Any exceptions in section 30?
I know, in the sense, exceptions in the sense, then we'll have to start from section 24. Confessions under certain circumstances are not being accepted. Beyond all that, section 30 is only what do you call, a section which is helping the court or helping the authorities to move forward with their investigation or case. So the scot-free as far as the criminal justice system is concerned. So that could be one of those ideas why section 30 has been incorporated. It is not an exception. As far as confession is concerned, yes, confession has been recorded only with a lot of rules. All those exceptions are from 24 onwards. So when you speak about a confession under section 30, we presume that all those tests have already been covered, or all those tests has been done with when you come to 30. So there again, we will not question the exception or anything. Under section 30, that confession that we speak about has been treated to be valid and not falling within the exceptions we have spoken in from 24 to 28. Under that circumstances, when 30 comes, that confession of a co-accused. So there, when you read with confession of the co-accused, the presumption is the confession that you make is well within the tune of Evidence Act, and you don't need any other exception to it. Because 30 is a plain section.
Yeah, there were only two questions. And tomorrow we have a session on how to create second income. This is wherein we are all talking about, one is an active income and one is the passive income, how to generate this thing. So we will be having Mr. Dr. Bharat Chandra, a renowned speaker, motivational speaker, coupled with a financial advisor. Do stay connected with us at 5:30 tomorrow. And meanwhile, Shania, it was an exciting session where one could learn a lot of nuances and the interplay between the various sections. Everyone stay safe, stay blessed. Thank you, everyone.
Thank you. Thank you so much.